team for joining us this morning. And I do recognize that we really do have some very familiar faces actually in the audience. And as Maurissa said, as we go through the presentation, if you should have any questions, feel free to post it on the chat so that at the end of the presentation, we will take those questions. And if we do have additional time available to us, we will allow you to actually ask the questions verbally. For the presentation this morning, we will not be using any video because sometimes it interferes with the quality of the broadcast. So we will just use our audio. And if I can kindly ask you to not unmute your microphone unless you are required to speak, because that also impacts on the quality of the presentation. So thanks very much for joining us this morning. Hope you have an enjoyable morning and learn some tricks of the trade in terms of the procurement, new legislation, and so on. So I'll get into the presentation in terms of the acts, the amendments, and the implications for public bodies. Act number 1 of 2015 that was passed around January of 2015 really is an act to provide for public procurement for the retention and disposal of public property in accordance with the principles of good governance. And you would see the terms, namely accountability, transparency, integrity, and value for money, which is really included in the preamble to the act. And the establishment of the Office of Procurement Regulations is established under the act. And it will also eventually, upon full proclamation, repeal the Central Tenders Board Act, Chapter 7191, and all related matters thereto, and I believe also Section 28 of the Tobago House of Assembly Act. So the Act covers all procurement and disposal actions. And you know, sometimes when you read and you hear people speak about the Act, there's a lot of emphasis on procurement, procurement, procurement act, but it's really equally geared towards procurement, retention, and disposal of public property. And we'll touch on all those areas. And it applies to all public bodies identified in Section 4. And in a couple of slides down the road, we will look at which or who constitutes public bodies. Section 64 of the Act provides for the repeal of the CTB, as we mentioned, and transference of the existing procurement proceedings under the purview of the OPR. So there will be a transition period when the CTB Act no longer becomes effective and the OPR officially takes over its mandate. Act number 5 of 2016, which was an amendment, the first amendment to the Parent Act of 2015, deals with the review board and the establishment of that review board to review decisions made by the Office of the Procurement Regulations as it relates to challenge proceedings. Each public body will be obligated to establish its own procurement department with the accounting officer, who in most cases will be the permanent secretary. And that person is accountable for contracts regardless of the size. So you have to set up your own procurement department, and every public body by definition has to have its own named procurement officer under Section 61 of the Act. As I mentioned, public bodies are defined in the Act, and it really seeks, the Act really seeks to bring all public bodies and the spending of public money under a single regulatory framework that covers all stages of the procurement process and the disposal of public property. So who are these public bodies? It is the Office of the President, and this is the President of the country, Her Excellency, and the Office of the President. Parliament, even though we report as a body to Parliament, Parliament also are obligated to follow the requirements of the Act. The judiciary, all arms of the judiciary, magistrate, Chief Justice, and that whole area, tax appeal boards and so on, they all fall under the Act. A ministry or department or division of a ministry, every single ministry, and I know we have a permanent secretary with us this morning, all the ministries and divisions, the Tobago House of Assembly, and a division of the THA, all municipal corporation and regional health authorities, statutory bodies, state-controlled enterprises, service commissions, a body corporate, which is, this one is particularly important because of some of the persons I see on the presentation this morning. You represent different stakeholders. A body corporate or incorporate established by the president, a minister, or another public authority performing a function on behalf of the state, and a body corporate or incorporate that uses public money. So all these bodies that benefit from the subventions that the government give from time to time, they are required now to be accountable for the monies that they have been allocated in terms of their spend. As I mentioned before, normally when you speak about the objects of the Act, persons will relate to accountability, integrity, transparency, and value for money. But it goes into some wider perspective that deals with different things like efficiency, fairness, equity, public confidence, and sustainable procurement, etc. So I'll go through briefly each one of those. Accountability speaks to, it allows really, and most people will know what accountability is. It allows interested parties, any member of the public, to ensure that the objects have been achieved. And the integrity of the system is really geared towards avoiding corruption and conflicts of interest and so on. And we do have a code of conduct that we have established that deals with the whole issue of conflicts of interest and so on for guidance of both public bodies and suppliers and contractors. And we have to be transparent in all that we do. So the appropriate information is placed in the public domain, and you will see later on in the presentation where some of that information is now made public, things that would have been hidden before and not made public, and you had to go through under the different legislation to get information and so on. That is no longer required. Value for money proposition is one that is key also, because not necessarily lowest cost is best value for money. And it includes the values that are derived from the optimal balance of outcomes and input costs on the basis of the total cost of supply, maintenance, and sustainable use. And I'll give you an example. For example, in the medical field, you often hear some stories that we have purchased this very expensive piece of equipment and it's not working because somebody forgot to put in place some warranty and some maintenance contract associated with that particular equipment. Now you are required, you are bound by law to make sure that you deal with the full value proposition, which includes things like maintenance, because then you are looking at the whole issue of value for money, and it deals with retention of public properties. The retention deals with maintenance and so on. Efficiency is really achieving the procurement objectives within a reasonable time and cost. This new act does not, it's a principle-based approach to doing procurement and disposal of public property, and is not geared towards, and we have already started hearing some stories that, you know, with the advent of this act, now procurement runs the company. Absolutely not. Procurement is there to assist in the running of the organization and making sure that things are done in a particular way, not just stymieing the operations of any ministry or any department of a ministry or public body. It's there to assist and make sure things are done in a very transparent way. Fairness is, or it has to deal with creating a level playing field where all suppliers or contractors are treated equally. And you'll see some of the things that we have put in place to ensure this. Gone would be the days when you have to pass something underneath the desk, as you would have heard in different forums and so on, and grease the wheels and so on. All those are things that we believe will be things of the past where suppliers and contractors are treated equally. Equity, speaks to everyone having a fair chance of winning a contract or a tender that is put out by a public body using public money. Public confidence is really key. Really, you must build that trust and confidence in the integrity of the procurement process. And for far too long, for the last 58 years, we have been hearing horror stories about some of the practices in our public sector and public bodies. Local industry development. Under the Act, we are trying to encourage as much as possible the development of our local industry. And where all things being equal, you have competition between local and foreign suppliers. There is a school of thought that we should give preferential treatment to the local industry development. And even though you have foreign suppliers coming in, we are looking at knowledge transfers and so on, transfer of technology, where you can partner with a local supplier and contractor to encourage the transfer of technology. And sustainable procurement, there's a lot being said right now in the world in terms of what's taking place with sustainability and sustainable development. So the last two there speaks to the whole issue of sustainable development. And you've seen within the recent past, the Office of Procurement Regulation have been taking a very key interest in terms of our sustainable development without compromising things like damage to the environment, and making sure that there is a long-term basis so that generations coming after us are able to benefit from what is taking place today. So who really is the OPR? The Office of Procurement Regulations, OPR, we were established by the Public Procurement and Disposal of Public Property Act 2015 as amended in 16, 17, and 20. It is, and we are a regulatory body governed by an independent board appointed by the President in consultation with the Prime Minister and the Leader of the Opposition. And all board members, you would see, if you look at the Act, they are required to have very special qualification and experience to complement the setting up of the office. The first board was appointed on January 12, 2018, and you will see some of the work that we would have done in setting up the organization to take advantage of some of the benefits that will be accruing to the country. And we will go through section 13 of the Act shortly. So the independence of the OPR was made clear in section 13(2)(b) of the Act, and it states that the OPR shall not be subject to the direction or control of any other person or authority in the performance of its function, but we shall be accountable to Parliament. So our report goes to the Parliament, the Speaker of the House, President of the Senate, and we send a courtesy copy to Corporation Sole in the form of the Minister of Finance. So what are some of the things we are responsible for? What are some of the roles? We are responsible for the oversight and control, and we are headed by a chairman procurement regulator and managed by the board that was appointed by the President. And we more or less oversee the whole requirements under the Act. And we are required to issue guidelines, and this is very important, and we need to understand this very clearly. The OPR shall issue guidelines, model handbooks, standard bidding documents for use in public procurement, and shall review special guidelines and handbooks for use by public bodies. So every handbook and guideline that you use for public procurement and disposal of public property, every handbook and guideline, whether you develop it yourself or it is developed by the office, and we have so far developed and issued 41 of these, and you will see those on our website. It must be approved, so you cannot do procurement activities without the approval of the Office of Procurement Regulations approving those handbooks and guidelines. And the OPR shall establish a comprehensive database of information on public procurement and tenders received, awards of value of contracts. So previously, it was difficult to find out who contracts were awarded to, the value of those contracts, and any variation orders and so on. So now, every quarter, 3 weeks after the quarter, for example, at the end of, let's say, March, in the month of April, 3 weeks after, you are required now to publish on our website And there will be a user ID and a password for the named procurement officer and the head of the organization, the accounting officer, to publish on our website all the contracts awarded, to whom it was awarded, the value of the contracts, variation orders, amount paid to date, outstanding amount, and any legal issues associated with those contracts, all unfulfilled contracts, all stop contracts, all terminated contracts. All those information now are required to be published, and that will form part of our report to Parliament, and then it becomes a public document to any member of the public to know what is happening. We have already set our training standards, competency levels, and certification requirements, and that's under the purview of Maurissa and her team to promote best practice in procurement. If you look at our site, you'll also see that. And we are required to prepare and maintain a database of all pre-qualified suppliers and contractors. So in other words, no longer is it required that all public bodies have their own list of pre-qualified suppliers and contractors, and they determine if and when they will pre-qualify suppliers and contractors and under what conditions. That is now done on one central database. The database is up and running. It has been commissioned. We have so far over 350 suppliers and contractors already on the system, and over 100 of our public bodies already have their user ID and password. So that is fully operational as we speak. We shall establish the procurement depository to which suppliers or contractors can submit information. So a prerequisite to getting pre-qualified in the previous section is that any supplier and contractor, and all the suppliers and contractors, as I mentioned, over 350, once you come on the depository and you register, you get a user ID and password, and then you are able to upload all your information, identify which line of business you want to deal with. And once you have put in all your information, it's automatically routed to a public body. The public body picks up that information and then pre-qualify you. So the depository is a prerequisite where you actually deposit all your information. It goes to the public body, you are pre-qualified, and then you are seen by all public bodies. So all public bodies now are obligated to use the list of pre-qualified suppliers and contractors. We would have heard a story that where a particular supplier would have applied for pre-qualification on 38 occasions with 38 separate public bodies. And not once was he pre-qualified. And for every single one of those 38 public bodies, he had to pay a fee to get pre-qualified. Now, no longer is that required. You are not required to pay a fee to get pre-qualified. It's a system that is totally transparent and free to all suppliers and contractors once you fulfill the requirement under Section 29(1) of the Act, which I'll come to shortly. We shall prepare and update and issue model handbooks incorporating standardized bidding documents. For example, as many of you have, as you have the regional health authority, regional corporations, you have different practices taking place within the 14 regional corporations and the Tobago House of Assembly. So we have standardized those documents. We shall approve in respect of each procuring entity special guidelines and handbooks. So if you use our handbooks and guidelines, those are called general handbooks and guidelines. If you prepare your own and you send it to us for approval, those are referred to as special guidelines and handbooks. So if you don't want to use ours, you can use yours, but it must be approved by the office. We shall promote the use of technology, and this has to do with things like e-procurement, reverse auction, forward auctions, and so on. And we have started that process in sensitizing the public bodies, and we have had so far about 5 different persons come into the office to show us what they are doing in terms of their e-procurement development. We shall provide best practice advice in the conduct of procurement activities. So even though the Act is not fully proclaimed, so far we have probably given advice in over 650 requests for advice in terms of procurement activities. Some of those we have them in our frequently asked questions and answers on our website. The OPR shall harmonize policy, systems, and practices in relation to public procurement activities. So we are harmonizing those as we speak, and that is really to look at best practice across all. So if you see a best practice being developed by a particular ministry, and I know like we have a number of Ministry of Trade persons on board this morning, we can look at a good practice in Ministry of Trade, and we believe that we should be able to share that with all the other ministries. Those are some of the things we'll be looking at. And then to review practice and delivery system on an annual basis. So even though it mentioned annual, we are looking at not only annual basis, but as often as is required, and whenever we see those best practices, we will be incorporating it. And like we are doing this morning, to promote the awareness of public bodies and to the public at large on issues relating to public procurement and disposal, we continue to have, and we have had so far, I believe, over 240 public consultation and sessions among different stakeholders, from large chambers to Rotary clubs to the Presbyterian Board of Education and different institutions. Last week, we would have had one with Tech, comprising of over 400 of their employees. And we continue to do these on a regular basis, sometimes 2 and 3 sessions per day. The OPR shall undertake research and survey. We have done an extensive amount of research in terms of developing our handbooks and guidelines, and we'll continue to do that. And of particular importance is this area of investigations. And we do have a team of investigators on board, and we'll be improving on that team, bringing in more investigators. And we will investigate on our own initiative or upon complaint from any party involved in public procurement and disposal of public property, or any member of the public, any alleged or suspected breach of this act. We have the powers to go in and investigate, to request and take away documents, and get in court orders and so on. All that is enshrined under the Act. So we do have wide-ranging audit and investigation powers. And we shall create and publish standard form of contracts. As many as you have public bodies, you have different forms of contracts that are being used, and sometimes they miss out very critical elements and clauses in terms of some of the standard form contracts. We are standardizing those contracts, and will be issued to public bodies. We shall prepare and maintain a list of pre-qualified mediators, arbitrators, and experts for the purpose of alternate dispute resolution. So if an issue comes to us and we believe that a better way of resolving it is by the use of mediators and arbitrators, those will be agreed upon, and that process will kick in. And the OPR shall provide advice and best practice on the aggregation of the procurement of disposal of goods for the purpose of obtaining value for money. And again, we are here to provide advice. So if there are questions that comes about in terms of the whole issue of the value for money proposition, we are willing to give our best expert advice. We do have teams on board that has a lot of experience and qualification in terms of procurement. So that said, any procurement of goods, works, and services, or retention or disposal of public property that is not done in accordance with the Act shall be void and illegal. So if you don't follow what is required under the Act in terms of achieving the objects of the Act, we at the office could make those void and illegal. And then, of course, the process will go through all the different reviews and so on. We may conduct audits and periodic inspection of public bodies and issue directions to them. So we have wide-ranging, as I said, investigation, but also audit. We are required to conduct periodic audit. So we'll go into the public bodies and audit their books to make sure that they are doing what they are supposed to do under the Act. And if we find that they are not in compliance, we will issue directives to remedy the situation. Something similar, but this is relating to public procurement, retention, and disposal. Unlike what the AG does, we could go into a lot more detailed auditing and investigation. UPR has the power to investigate any alleged breach. I would have mentioned that before. And this is under sections 41 to 48. We can, if we find that you are in breach and you have committed an offense under the Act that is prosecutable, we will then send that to the Director of Public Prosecution for prosecution, and they will take it through the courts and so on. We must submit an annual report to Parliament, including the total number, as I mentioned before, and value of contracts awarded by public bodies, the number of unfulfilled procurement contracts, and those bodies that have failed to comply with the Act. So if you fail to comply with the Act, it will be reported. In addition to some other remedies that we can have under the Act, we will report it to the Parliament. One of the new things that, and this again is in terms of full transparency and so on, all public procurement activities, a procuring entity shall, and whenever we see the word shall, we know it's mandatory, no later than 6 weeks after the approval of the national budget, publish on its website or in any other electronic format information regarding all the planned procurement activities for the following 12 months. And we have gotten a lot of questions. Well, what about small procurement? The Act says all. And you could consolidate some of the small ones, but you must report it and publish it so that all members of the public will be aware of what is coming through the pipeline in the next 12 months. You are able to update the information regarding referred to in paragraph A if there is a change that necessitates the updating, and then republish. And if required, any member of the public could ask for a printed copy of that information. And of course, you can charge a small fee for the cost of printing, not the cost of preparation. Where the information is not available or not forthcoming, anyone can make a complaint to the office and we will conduct an investigation, and then, if justified, grant an extension of time or issue such direction as we think fit under section 27(2). So some of the highlights I would have mentioned: the depository before. The office shall establish this database to be known as the depository, to which suppliers or contractors shall submit their information and their qualification and experience in terms of under section 26(1). But the depository is not only for public bodies, but also accessible to the public for viewing. It doesn't mean that the public will have access to get a user ID and go in and interrogate the system and so on. So we will provide information for viewing in the form of reports for the public to get that information. So whatever information they require, we will provide those reports. The supplier and contractor is the one responsible for the accuracy of that information provided under section 26(3). And the public body, in conducting its due diligence pursuant to 29(1)(e), a procuring entity may require a supplier or contractor who has submitted information to the depository to confirm the accuracy. So even though the supplier contractor has put in that information, they get pre-qualified during an active tender, the public body is in their right to ask for confirmation or for the supplier contractor to revalidate that information. So under 29(1), these are some of the things that we look at when we are assessing the supplier and contractor in terms of their eligibility to be pre-qualified. They must have the legal capacity to enter into the procurement contract. They are not insolvent, in receivership, bankrupt, or being wound up, or their affairs are not being administered by a court or judicial officer. Their business activities have not been suspended, and they are not the subject of legal proceedings for any of the foregoing. The part that you are seeing highlighted there under C is an area when we took over, we were a little bit concerned. This has been changed under the amendment in 2020. It would have said previously that if you have been convicted of a criminal offense, you were not eligible to be part of the pre-qualification exercise. What that would have done is to literally exclude a substantial portion of persons in the country who have been convicted of very small, minor criminal offense or offense that really has nothing to do with procurement. So we asked it to be changed, and this is what it was changed to. Have not been convicted within the past 10 years of corruption or fraud-related offenses locally or internationally as individuals or as directors or officers of a company. So that has changed now to give, if you're looking at restorative justice and so on, persons an opportunity to come back into the system. It goes on under D in 29.1, have fulfilled their obligation to pay all required taxes and contributions in Trinidad. So all persons who register in, whether or not you're a single person, a consultant, or any other company or partnership, you must fulfill the obligation to pay all required taxes and get that certified by the Board of Inland Revenue. Have the necessary professional, technical qualification and competence, financial resources, equipment and other physical facilities, managerial capabilities, reliability, experience, and personnel to perform the procurement contract. So if you are vying for a huge multi-billion-dollar contract, you must be sure that you have all these different things in place. If you're a single person, like doing a small consultancy service and so on, you may not have to have all these requirements. So it depends on where you are being pre-qualified will determine what you will have to fulfill under E. And you must meet all relevant industry standards. For example, if you are providing, let's say, scaffolding services in a live plant like, let's say, PPGPL, which is a state enterprise under NGC, you must meet certain requirements that you are so certified to work in a plant, a live plant environment. So those are some of the things that we'll be looking at in terms of your pre-qualification. And of course, this goes equally to all suppliers and contractors in terms of pre-selection and any solicitation documentation. So it's an equal playing field level. Now, so we have introduced in the Act what we refer to as a standstill period. And this standstill period means the period from the dispatch of a notice as required under Section 35(2), during which a procuring entity cannot accept the successful submission and suppliers or contractors can challenge the decisions to notify. So in simple language, once you have gone through your procurement activities, you have stipulated there will be a standstill period in your solicitation document. You are required to stand still before you award that contract for a period of between 10 and 15 days. So when day 0 comes of that 10 to 15 days, you have to notify after you have done your evaluations and so on. You notify all the suppliers and contractors who was part of the process that you are going to award the contract to supplier A at price B. And you must give that information to all the suppliers and contractors and give them an opportunity to ask for a review. They then ask for the review and they say, well, could you please tell me why I was not successful or would not be successful? And you are obligated to give them the reasons. Once there are no further clarifications sought by the active participants, you can then go ahead and award the contract. And once you have awarded the contract, there is no room, after you have given the opportunity, there is no room to come back now and ask for a review after you have given them the opportunity. So it prevents frivolous actions to be taken after the fulfillment of the standstill period, and you are free to award that contract. If, however, you have an emergency, you do not necessarily have to have a standstill period during a time of emergency where you go ahead and procure. And of course, you will have to fulfill the requirements in your procurement file as to why you considered it to be an emergency and so on. So retention and disposal, I mentioned that we would have had equal weighting in terms of retention and disposal. Disposal of public property includes the transfer without value, sale, lease, concession, or other alienation of property that is owned by a public body. So by definition, all public bodies fall under the Act in terms of retention and disposal. Public property means real or personal property owned by a public body, and this is contained under Section 4 of the Act. And a public body shall comply with such general guidelines in relation to retention and disposal as the office may issue. So we have already issued those general guidelines. You will see it on our website. And if you don't use the general guidelines, you can develop your own special guidelines, as I mentioned before, and get it approved by the office. I would have mentioned that you have a process now of challenge. So we at the office now are responsible for hearing all challenges coming from suppliers and contractors, but it's not for every and anything that a challenge could be made. A contractor or supplier can bring a challenge where it is alleged, not proven, that will be proven to a review panel at the OPR, where it is alleged that the procuring entity made a decision or took an action that is not in compliance with the Act, and the supplier contractor has suffered or likely to suffer loss or injury because of the decision or action. So there's a process that must be followed. There's a form that has to be filled out. You have to say which part of the Act is not in compliance and how are you likely to suffer loss or injury. Once that comes to the office, you ask for a review, and the supplier contractor does the application, and we will give the opportunity to the public body to respond to that. So the public body has equal opportunity to respond to it, but you must say which public body and give as much details as possible to allow us the privilege to get a proper hearing going. So the application for review shall be submitted in writing within the following time periods, and these are the things that falls under to be challenged. Application for review of the terms of solicitation, pre-qualification or pre-selection, or a decision or action taken by a procuring entity in pre-qualification or pre-selection proceedings prior to the deadline for presenting submissions. So this has nothing to do with after the submission of bids and so on. It's before you have submitted your bids. If you think something went wrong in terms of solicitation, pre-qualification or pre-selection, you can ask for a review at that stage. Additionally, for other decisions or action taken by a procuring entity in the procurement proceedings within the standstill period, so that is within the 10 to 15 days under section 35(2), or I would have mentioned that you don't necessarily need to have a standstill period under certain circumstances. When no standstill period have been applied, within 7 working days after the publication of the notice of the decision or action that is taken in accordance with the Act. So you have a 7-day window after the award of a contract when no standstill period has been applied to actually make an application for review, where the contract was awarded in this case, where no standstill period. So I hope you follow the sequence in terms of how you can go about doing that. And within 3 days after we receive the application, we will publish it in 2 newspapers in daily circulation in Trinidad and Tobago, and in any other, in our website and any other electronic form. And within 3 days after that, we can, based on the information we receive and the response of the public body, if any, order the suspension of the procurement proceedings at any time before the entry into the force of a procurement contract. So that's within the 7-day window. Or order the suspension of the performance of a procurement contract on the operation of, or the operation of a framework agreement that has entered into force. So even though you have entered into force in terms of a framework agreement or a contract, we can order the suspension if we find such a suspension is necessary to protect the interests of the application of the applicant. And we can do that for as long as we believe is necessary. So you are a supplier and a contractor, you are working with the public bodies, and then we start to see a deterioration in your performance. So you can be added now on what we refer to as an ineligibility list, and we can add a supplier contractor to this list under section 58(3). If the supplier contractor consistently failed to provide satisfactory performance, the key word consistently, and an application is made to the office for review. You have been found to be indulgent in corrupt or fraudulent practices, or is convicted of an offense under this act, then under B and C, you can be disqualified and placed on the ineligibility listing for 10 years, not up to 10 years. And under A, if you consistently fail to provide satisfactory performance, you go on the ineligibility listing for a period of between 1 and 10 years. And this is now contained in regulations. And of course, the supplier contractor shall be afforded adequate opportunity to be heard, to make representation, whether it's legal or otherwise, before he or she is added to the ineligibility list pursuant to section 58.3. So there will be a fair treatment for both suppliers and contractors and public bodies to be heard under this situation. The decision made here by the office is not subject to the review of the review board. So some specific things, just by recapping, some of these we would have mentioned before. It is now under, once we have the full proclamation, the removal of the CTB. So the public bodies now have to carry out all their procurement and disposal activities on their own. That's why you have to set up your own procurement department and also name your procurement officer under section 61.2 and establish a disposal committee to do disposal. Disposal committee is enshrined in the Act. And under the methods and procedures, section 29 of the regulations, we have now established the Procurement and Disposal Advisory Committee. And you can see that under the regulations. And as part of that committee, you are required now to have your head of finance or corporate secretary, head of legal or corporate secretary, head of finance, and a subject matter expert with a recording secretary, part of the committee that takes the notes and so on and sort of manage the affairs of the PDAC. The named procurement officer is not part of the PDAC. That person reports and sends their recommendation to the PDAC for review. The PDAC is not an approval committee. The PDAC makes recommendation to the accounting officer for approval of contracts and disposal. We mentioned it is the development of the annual procurement plan and the approval of handbooks and special guidelines, the general and special guidelines. And you also have to implement internal control framework to guide your procurement and disposal activities, which includes the role of your internal audit department. Now, these are slides we normally don't like to put too much information and get people scared and so on, because people said we out to lock up people and so on. But no, really, we are here to work with everybody. But people will, from time to time, kind of get go afoul of the law, and this is what happens. So failure to comply with the direction of the OPR is a penalty of 100,000, small fee, no jail term and so on. Failure of a member of the board of the OPR, a committee constituted by the board, knowingly or willfully to disclose an interest during a hearing proceeding and so on, 500,000, and from here on in everything is and 1 year in prison. And you will see it is not only directed at the named procurement officer, but anybody involved in the activity. Splitting of procurement, 500,000, 1 year. Failure of a procuring entity to comply with requirements with respect to confidentiality of information, 500,000 and 1 year. Victimization, if somebody reports and you victimize them, 500,000, 1 year. Failure of a person to report instances of collusion, 500,000, 1 year. Any false report to the office that is proven, 500,000, 1 year. If you conceal or destroy information required for an investigation, and this is very important, you are required as a public body to keep all information associated with procurement activities. Failure, or if you conceal that or destroy it or do not have proper systems in place to safeguard the information, it is $5 million and 10 years imprisonment. And that's a significant penalty. Failure to comply with the requirements with respect to confidentiality during the challenge proceedings that I would have mentioned, 500,000 and 1 year. Conduct influencing public officers, including bribery, conflicts of interest, corrupt, fraudulent, collusive, coercive, or obstructive practices, $1 million and 5 years in prison. Bid rigging to influence the procurement proceedings and outcomes, $5 million and 10 years. Altering a procurement document to influence the outcome, $2 million and 7 years. Contravention of a regulation made by the minister on the recommendation of the OPR, up to $1 million and 5 years in prison. And that little fancy stuff that you see underneath there, it just depicts what could happen. You could end up in tears if you don't follow what is required under the Act. So, where are we in terms of the status of the Act and draft regulations? This just gives you a chronological sequence of how we went about drafting our regulations and the process that we would have followed since 2018 November up until most recently, when on July of this year, the Minister of Finance would have submitted those regulations for debate in Parliament, and we are hoping that those will be debated very early in September in the new term of Parliament. So some of the key features of the Amendment Act in terms of 2020 December that would have, caused a lot of debate in Parliament and in the public domain. Some of the features, the first one is the definition of bid rigging. We felt that the definition that was contained in the original Act did not constitute an offense. And we sought legal advice, and we asked the ministry through the Attorney General to redefine the definition for bid rigging, and that has now been done, and it now constitutes an offense under the Act. Section 7, you would have seen some amendments to the Act under Section 7.2 that include some changes and exclusions under the Act. Disposal of public property, previously under Section 13.1.0, we were required at the office to dispose of real property in accordance with the government's mandate. We believe that that was a conflict of interest. We should not be disposing of real property and then coming back under Section N of Section 13.1N to give us the powers to investigate something that we are involved in. So that was clearly a conflict, and that now have been removed under the purview of the OPR and has to be given to another public body to do. Criminal offenses, the fourth feature, and we'll go through in all of these in a little while. The time for decision has been changed after a review by the office from 20 days to 30 days. And conduct influencing public officers, some definitions there we would have asked, including some additional words and the options available to public officers. We'll go through that also in a while. So the proclamation, this is a matter that the law, which is in the form of a bill, then goes to the House, and the House constitutes the Senate and the lower house. And after the debate has gone through its process, then it goes to the President, and after the President has given her assent, proclamation based on the recommendation of Cabinet. So all that is the process that we'll have to follow through in terms of the regulations. So the definition for bid rigging was changed from collusion between persons for the purpose of manipulating the proceedings to, it reads now, collusive price fixing and anti-competitive behavior which is designed to unfairly influence the outcome of a competitive tender process in favor of one or more bidders. And we would have done research in terms of what is acceptable internationally to arrive at this particular definition. So we believe now we're on safe grounds to start investigations and so on in terms of bid rigging. This would have created a lot of discussion at the Parliament and independent senators stage in terms of the amendment. Section 7.2, to the extent that the Act conflicts, which is key, with an obligation of the state under arising out of the following: a treaty or other form of agreement which Trinidad and Tobago is a party with one or more states or entity within a state, an agreement entered into by the government of Trinidad and Tobago with an international financial institution, World Bank, IADB, Caribbean Development Bank, etc., CRAF, an agreement for technical order cooperation between the government of Trinidad and Tobago and a foreign state. Previously, it would have stated the requirements of the treaty or agreement shall prevail, except the procurement of goods, works, or services shall be governed by this Act and shall promote the socio-economic policies of Trinidad and Tobago and shall adhere to the objects of the Act. So the part in red there that you see has now been excluded from the Act. So it stops at the requirements of the treaty or agreement shall prevail. However, under Section 3, which a lot of people did not go on to read, it still says that even though that part has been excluded, a procuring entity engaged in procurement proceeding relating to a treaty or agreement referred to in Section 2A, which is between the agreement with a state or entity within a state, shall comply with Section 29, which we would have gone through. So even though that is excluded, the procuring entity shall still comply with Section 29 and submit a report on such compliance to the office. So first of all, you'll have to determine that there is a conflict under Section 7.2. Following that conflict, you have decided to go with the treaty or agreement. And after that, you have to report that you are in compliance with Section 29 and report that. And once that report comes to us within 21 days of receiving it under subsection 3, we will forward a copy to the report of that report to the Speaker of the House of Representatives, who shall cause it to be laid in Parliament. So there is a protection still under Section 7.2. Section 7.3 now, a procuring entity engaged in procuring proceedings relating to a treaty or agreement referred in Section 2A shall comply with Section 29 and submit a report on such compliance to the Act. But what has been included now, that subsection, the above subsection, no longer applies to reports relating to national security. So it protects certain national security issues relating to procurement from being reported. And also there was an amendment to state that legal services is now excluded. Debt financing services, and there's not all debt financing services, but debt financing services for the national budget, accounting and auditing services. And this one, some persons would have gotten a little bit confused. Medical emergency. And we never expected medical emergency to be part of procurement activities where you have competitive bid and so on, or other scheduled medical services. So it does not include goods relating to medical. So it only includes emergency and medical services. So goods still falls under the Act. Only where the goods are ancillary and forms a small part of medical services, by definition, it will be excluded. But all the procurement of goods associated with the medical profession falls under the Act, or such other services as the minister may by order. However, even though these will no longer apply, the minister shall submit to the office annual guidelines which outlines the circumstances under which these exempted services in subsection 6 may be procured. So you still have to follow certain guidelines as issued by the minister and sent to the office so that we will know whether or not you are following those guidelines or you are outside of those guidelines, and we can then trigger an investigation. Under Section 13.1, I mentioned that we will not be acting for and in the name of on behalf of the state to dispose of real property. Coincidentally, the Ministry of Finance, the Minister of Finance have now to develop the regulations and lay those regulations for negative resolution in Parliament associated with real property. And I mentioned that the office now gives all its decisions within 30 days and not 20 days as previously would have been in the Act. We have expanded this now to state that a relative is now defined as a common law relationship under Section 59(1). For the purpose of Section 1, relative means a spouse, and in red is the additional part, cohabitant within the meaning of the Cohabitational Relationship Act, father, mother, brother, sister, son, or daughter. So it is expanded for common law relationships. So let me say thanks very much for your undivided attention so far. That brings me to the end of my part of it, but I'll be sitting here waiting for those questions that will come up after these sessions. So I'll hand you over now to Maurissa, who will take you over to NQS.
Thank you, Mr. Lalchan, for taking us through that very informative presentation on the Act, its amendments, and the draft regulations. So before we go into the presentation dealing with the National Quality Infrastructure, we will take a 10-minute break to allow you to stretch your feet, get your coffee and water, and we will get back at 10:10. So thank you very much for your attention thus far. I will take you through the area of the Act that relates to the NQI. So there are 4 key components of the National Quality Plan. So for the purposes of today's session, we will discuss components 3 and 4 as we see those directly relating to and affecting or benefiting the legislation on procurement and disposal activities in Trinidad and Tobago. So component 3 addresses projects that strengthen the institutional capacity of quality infrastructure related agencies and key stakeholders. And component 4 focuses on building a high level of quality intelligence and quality consciousness amongst all stakeholders in Trinidad and Tobago. So in accordance with the implementation plan for the NQP, Component 4.4 speaks to the development and implementation of a program to relate the quality policy to public procurement. And as it pertains to Component 3, it deals with the development of a training program for the Technical Regulation Coordination Committee and good regulatory practices promoting quality in the procurement processes in both the public and private sectors. And component 4 deals with quality intelligence and quality consciousness that describes the target characteristics of the demand side of quality infrastructure. And this is in reference to especially ISO 9001, the Quality Management System Standard. So areas of the Act that these components apply to would be value for money. And I know Mr. Lalchan would have spoken to these areas in terms of the definitions before. Local content and local industry development, sustainable development, and sustainable procurement. So Section 4 of the Act defines value for money as including the value derived from the optimal balance of outcomes and input costs on the basis of the total cost of supply, maintenance, and sustainable use. So broadly, there are 3 components of value for money, and these are effectiveness. So this is getting the expected results from the inputs and outputs. In order to achieve this, items procured must meet the needs of the most favorable delivery conditions, and they must be functional, and they must be readily available. As it pertains to economy, getting the right inputs at the most economic cost. To achieve this, procurement practitioners would utilize the selection process of the most economically advantageous tender, which includes an evaluation of price and quality and efficiency, getting the most from the inputs during its life cycle. So this is achieved by doing a life cycle cost analysis, which is an economic evaluation technique that assesses the total cost of an asset over its operating life, including initial capital costs, maintenance costs, operating costs, and the cost of benefit of the eventual disposal of the asset. And Mr. Lalchan would have spoken to the concept of value for money and low price not necessarily determining that value for money is being achieved. So in a nutshell, value for money entails balancing the principles of quality, economy, and efficiency and it addresses the concern of obtaining quality by allowing procurement practitioners to incorporate issues of reliability, performance, maintenance, and any other factor that determines quality into its procurement decisions. So one of the major challenges in achieving value for money is the quality of goods on the market, or the quality of goods actually being procured by public bodies. Given the limited resources available to the government, ensuring value for money in procurement is key to achieving the optimum utilization of scarce budgetary resources. The quality of goods as inputs in procurement processes is identified via requirements or specifications that are developed by public bodies, and these must be included in its solicitation documents. So the specifications. Specifications are the exact statements used by procurement practitioners to communicate the particular need to be satisfied or the essential characteristics that a public body requires in a good or service which a supplier or contractor must deliver. They are required by procurers in the purchase requisitions raised by users. They are part of the procurement interaction documentation, and they play a key role in the procurement process. During a tendering process, quality is a key selection criteria. The public sector has a critical role to play in ensuring quality service alongside value for money, and therefore it is vital that all businesses have adequate systems and procedures in place to fulfill this requirement. So requirements can take three forms. So it can be specifications, and these are used for goods or equipment. Terms of reference, and this is used particularly for services, or statement of work, and these are used for works. Specifications may be developed as one or a combination of the following type of specs. Functional specifications, and these concentrate on the function or purpose of the product. Performance specifications, and this describes what is to be achieved rather than a fixed description of how it should be done. And technical specifications, and this defines exact design and details of a good. Technical specifications may also take a long time to create due to the detailed and complex nature, and we see how the quality infrastructure will be very, very important in terms of the defining technical qualifications for suppliers and for public bodies. So one of the benefits of the implementation of a robust quality infrastructure in Trinidad and Tobago is on the development of specifications or technical requirements within the procurement process is the improvement of clarity of specifications being developed by public bodies. In the implementation of the framework to guide the production of local goods and services in keeping with internationally accepted standards, the quality infrastructure will enhance product quality and compatibility by offering proof that products and services adhere to the requirements of national standards. Standards provide a clear indication of the levels of quality or other critical performance requirements for goods, works, and services. Quality standards ensure that specifications or requirements from public bodies are non-discriminatory, clear, and do not create unnecessary obstacles to awarding contracts. In the absence of established national standards, public bodies in developing their specifications or requirements may underspecify, and this poses a risk to the scope, cost, and timing of the delivery requirements. Or you may see public bodies overspecified, which unnecessarily narrows the market, it increases costs, and it reduces the opportunities for suppliers and contractors to offer innovative solutions to procurement issues. Suppliers or contractors have often commented of the various specifications requirements requested by public bodies for identical goods or services. So standardization limits the scope of government-led standards, and it supports the development of social organization standards. As such, the quality infrastructure will lead to more transparency for suppliers and contractors, as there would be uniformity in the specifications developed by public bodies for these goods and services that fall under the quality infrastructure. And I do believe it was reported in the Business Guardian that the quality infrastructure being developed will address standards and metrology development in areas such as utilities, food and drugs, the environment, and health. So the quality infrastructure will provide an enabling environment for public bodies to procure better, safer, and more sustainable products. And the development of the certain requirements or specifications would fall under the quality infrastructure will be done in a less ad hoc manner by public bodies. It also reduces the cost of procuring goods and services by public bodies via the implementation of standardization, metrology, accreditation, and conformity assessment services that will take the form of inspection, testing, and certification. These are all necessary to provide acceptable evidence that products and services meet the national standards and that the defined requirements demanded by public bodies. So the standards of standardization reduces transactional costs in public procurement for both the public body as well as the supplier contractor, as there's less cost associated with developing the specifications by public bodies, as public bodies would now be able to utilize the national standards created for those products and services as part of their specification or requirement development. So by establishing these national standards, public bodies can design specifications that create or criteria that underpin the national standards. Similarly, shorter lead time in delivery of critical inputs and services due to the inspection and testing services from the quality infrastructure. The certification process will be optimized and the time for administrative approval reduced. Less time will also be spent in the aspects of procurement planning and market research stages that must be done by public bodies. Less time will also be spent in evaluation of bids for goods and services governed by the quality infrastructure, as there will be uniformity in the goods and services being offered, as they would now meet national standards. The theory of value engineering basically advances that a major part of procurement quality control is achieved via the standardization of certain specifications. The introduction of value for money as an object of the Act purports that public bodies accepting the lowest price, as Mr. Lalchan stated, is not necessarily an indicator of achieving value, but that quality and whole life costs must be factors taken into consideration in the making of public procurement decisions. So that is just a synopsis of how quality infrastructure will impact achieving value for money by public bodies, especially as it pertains to the creation of specifications and technical requirements. So we will go into local content and local industry development. Section 4 of the Act defines local content as a local value added to goods, works, or services measured as an amount of money or percentage of each dollar of expenditure remaining in Trinidad and Tobago after the production of the goods or the performance of the works or services. Local industry includes those activities that serve to enhance local capacity and competitiveness by involvement and participation of local persons, firms, and capital market and knowledge transfer during the conduct of the program of goods and services that are being procured. Section 28 allows a procuring entity to limit participation in procurement proceedings to promote both local industry development and local content. Some tools in local content and local development are utilization of the national competitive tendering where appropriate capacity and competitiveness exist in the local market, and we will discuss this a little further down. Reservation of contracts, and this is being done within a geographical catchment area by regional corporations. So Mr. Lalchan would have basically discussed in other presentations where if there is sufficient suppliers or contractors being able to provide a particular good or service in a catchment area, that a public body requesting that particular good or services within that catchment area will have the opportunity to utilize those suppliers or contractors within that geographical area. The use of subcontracting to develop the capacity of small, medium enterprises or micro, small, and medium enterprises, the allocation of lots in tender documents, as well as allowing domestic preference where the socio-economic policies support the development of a particular sector. And we see that the Quality infrastructure will also govern the food and beverage sector. So this is a possibility in terms of that policy. Regulation 3.1 of the Public Procurement and Disposal of Public Property Participation in Procurement Regulations provides that bidders participated in international competitive bids may benefit from domestic preference mechanisms set out in the bidding documents under the following conditions. And we will just briefly discuss some of the conditions that suppliers and contractors must meet in order to participate in domestic preference. So in the case of goods contracts, preference may be applied to bids that propose a supply of goods manufactured exclusively in Trinidad and Tobago, or goods partially manufactured or assembled in Trinidad and Tobago, where the supplier or contractor establishes to the satisfaction of the public body that a portion of domestic value added to the total value of manufactured or assembled goods is at least 35% of the ex-works price of the goods offered. Regulations 2 and 3 respectively states, in establishing the domestic value added in accordance with Regulation 3.1b above, the procuring entity shall take account of the value of domestic labor, raw materials or components manufactured within Trinidad and Tobago, as well as the value of any manufacturing and or assembly carried out in facilities within Trinidad and Tobago. As part of the bid, suppliers and contractors are required to certify that the necessary manufacturing capacity actually exists where domestic value is to be added. Regulation 3.4, a supplier contractor who participates in an international competitive bid may benefit from domestic preference mechanisms set out in the bidding documents where the procurement involves the performance of works and the supplier contractor proposes the employment of at least 65% of domestic labor. So local content as well as local industry development can bring significant social and economic benefits to communities by stimulating domestic economic activity. It also stimulates domestic investment through local suppliers engaging the services of other local suppliers via subcontracting, and the benefits from this resource development can flow into our local communities. Local suppliers and contractors have often opined that goods or services they provide are procured by government agencies from foreign suppliers. However, public dialogue has also advanced the argument that if the government is to create policy to reserve a portion of public contracts to micro, small, and medium enterprises, these enterprises must be able to provide quality, safe, reliable, and environmentally compatible products consistently. So to be able to benefit from domestic preference regulations, local suppliers and contractors must be able to offer goods and services that adhere to required technical, environmental, and labor standards. By implementing a quality infrastructure at the local level, the establishment of metrology, standardization, conformity assessments via inspection and testing, as well as accreditation services, which helps to verify that suppliers and contractors have actually met the national standards, as well as international benchmarks, signals to public procurement practitioners and the public at large of the capabilities of local suppliers and contractors within the value chain, that they actually have the capacity to participate as well as add value within a local content and local industry landscape. Quality infrastructure also allows domestically produced goods and services to be more competitive against imported products in the local market, which can mean more suppliers and contractors are able to participate and benefit from these domestic preference reservations. By implementing quality infrastructure, we hope to see the building of a cadre of suppliers and contractors that can assist in achieving the principles of value for money by increasing competition due to the increase in the numbers of capable suppliers and contractors available within our local markets. And we go into just some key considerations of the local content and local industry development requirements. So as discussed before, local firms must possess the capability and the capacity to complete or supply the required goods, works, and services, and to actually be able to compete against international suppliers. It also serves to enhance local capacity and competitiveness by the involvement and participation of residents, firms, and capital markets. And these are specifically targeted to the micro, small, and the medium enterprises. Knowledge transfer during the procurement and the use of goods, works, or services that are being procured. So if you have a supplier contractor that is benefiting from domestic preference regulation, they should be able to have some knowledge transfer if they're also doing the project with an international supplier contractor. There are opportunities for growth, improved national and international reputation, and this is due to the building of competent and experienced suppliers or contractors that will also have the ability to innovate, as well as increase diversity of markets. And this is very important as it pertains to local content and local development, industry development, but also as it pertains to the quality being offered by suppliers or contractors. Because earlier in the presentation, Mr. Lalchan would have spoken to the ineligibility listing. And it basically states that failure of suppliers and contractors to provide satisfactory performance will, if they are to be placed on the ineligibility list, this will be for a period of 1 to 10 years. So we see where suppliers and contractors must be able to consistently provide quality in terms of public procurement and disposal. So we go into sustainable development and sustainable procurement. So sustainable development is basically the idea that human societies must live and meet their needs without compromising the ability of future generations to meet their own needs. That is, without the depletion of natural resources. Section 4 of the legislation defines sustainable procurement as the process whereby public bodies meet their needs for goods, works, and services in a way that achieves value for money on a long-term basis in terms of generating benefits, not only to the public body, but also to the economy and the wider society, whilst minimizing any damage to the environment. The achievement of Sustainable Development Goals, or SDGs, and the effective implementation of sustainable public procurement in Trinidad and Tobago requires a radical change of economic activities, social practices, as well as human behavior. And we believe that the quality infrastructure system, with all its building blocks in place, that's standardization, metrology, accreditation, and conformity assessments, will play a major role in assisting in this transformation. So these are some themes in terms of Vision 2020, and they speak to customer-focused public service delivery, the strengthening of environmental governance and natural resource management, and the production of high-value products and services by local firms. And these all impact sustainable development and sustainable procurement policies and practices. So the 3 pillars of sustainable development. Efficient procurement practices coupled with quality infrastructure can encourage or lead businesses to adopt more appropriate and new technologies and organization methods, leading to the improvement in current policies, practices, and supply. For business to be truly sustainable, suppliers and contractors must take a holistic approach to their business practices, whilst procurement practitioners need to carefully balance each of the considerations of the 3 pillars in their purchasing decisions. So as it pertains to the environmental pillar, this requires both suppliers and contractors to minimize the impact of their manufacturing and supply processes on the environment, as well as procurement practitioners to take the environmental impacts of their purchasing decisions in terms of the products and services they procure into consideration. The social pillar, which focuses on people, requires sustainable businesses to have the support of employees, customers, stakeholders, and the communities at large in which they operate, and to ensure that these suppliers or contractors are aware of how their actions reflect on those around them in order for them to be a good neighbor, both locally and globally. Procuring entities as well must ensure that suppliers and contractors engage for the provision of goods or services observe the social requirement for sustainable development and sustainable procurement practices. The economic pillar ensures that although business must be profitable to be sustainable, that it is not at the cost of social and environmental pillars. So we will briefly discuss some benefits of the quality infrastructure on sustainable development as well as sustainable procurement. So in terms of the economic factors, in developing standards for goods and services, this can lead to reducing the costs associated with developing specifications by public bodies. It also allows for consideration of quality in our acquisition decisions as we try to save resources spent on poor quality goods by implementing life cycle costing, and this will include price, maintenance, operations, and disposal. And this can result in more economic, efficient, and effective procurement practices, basically on the way to achieving value for money. Building competitiveness will lead to sustained economic development, employment, improved trade and investment as well. In terms of the social factors, by building competitive business through the quality infrastructure and developing standards will encourage local businesses to not only compete internationally, but nationally as well. And this will impact the standard of living, assist in the eradication of poverty. It will address aspects such as distribution of resources, developing local communities, employment and economic securities for families. This also has the potential to address inequality in the distribution of resources by allowing micro, small, and medium enterprises to participate and compete globally. It can impact our labor conditions through the implementation of quality processes. The environmental factors. By taking environmental factors into consideration in developing standards, it ensures that factors such as GHG, which is greenhouse gas emissions, resource depletion in terms of water, energy, and raw materials, and the release of harmful chemical substances into the environment are automatically factored into all of our procurement decisions in terms of procuring of products, services, and works. It considers the environmental impact that the assets, goods, or services have on the entire life cycle, as well as incorporating sustainable practices and products into the procuring decisions of all public bodies. Sustainable procurement is considered best practice that can lower life cycle costs, spur innovation, and contribute to the achievement of more sustainable consumption and production patterns. Some benefits of sustainable public procurement are controlling costs by adopting a wider approach to whole life costing, achieving internal and external standards, complying with environmental and social legislation, managing the risk and reputation of all public bodies, creating new vibrant markets, ensuring security of sustainable supply for our future generations, and ensuring maximum community and financial benefits. However, there exist some barriers to sustainable development as well as sustainable procurement. And this includes, as I discussed earlier, difficulty in changing procurement behavior in terms of encouraging public bodies to take environmental, social, as well as economic consideration into their procuring decisions, lack of suppliers who produce sustainable assets, works, and services into the market for public bodies to actually be able to procure, complexity of comparing cost and value for money assessments, failure to include factors other than environmental ones into consideration because you do have the social as well as economic side, and perception that the process and outcomes are more timely or costly. And the table provides some sustainability criteria that procurement practitioners take into consideration or must take into consideration in their procuring activities. So in terms of the environmental aspect, fit for purpose and provide value for money. So they must ensure that the product being considered does the job that you want it to do for all potential users, including groups with special needs. Biodegradability, some products may be sustainable for composting. Where that is the case, you must ensure that the materials can be broken down speedily and safely, designed for disassembly, where products are made up of thousands of different parts and material, more specifically in terms of plastics and metals. It helps if they're designed to be easily taken apart or disassembled so that the materials can be recycled. And this is relevant specifically in terms of electronic and electric products. And this will be refrigerators, televisions, computers, and whatnot. Minimum use of virgin and non-renewable materials. So whenever possible, the use of recycled or reused materials should be encouraged in terms of public procurement decisions, as these generally have a much lower impact on the environment. Resource, energy, and water efficiency. Running costs are often overlooked when procuring products. So seek equipment that are energy efficient. And we have some eco-labels, so you have your Energy Star rated products. Also confirm that the products do not have a knockout effect of using more resources, which also has an additional cost. Fault controls to prevent unnecessary waste. When procuring plant equipment such as boilers, you ensure that you specify metering and monitoring equipment. So while it may increase your initial acquisition costs, it will alert you to inefficient use and enable you to reduce your running costs. And this is where whole life cycle costs comes into play, spills and any waste problems. Maximum durability, repairability, and recycling. Essentially, this is a quality issue. So we prompt them to seek long life products that will survive being mistreated, that can be repaired, reused, and ultimately recycled. See products that enable you to upgrade them and improve performance over time rather than having to procure new equipment to do the same job. Minimum packaging. Most products are bought with excessive levels of packaging. Either this could be to add cosmetic value or to enable the product to survive poor handling. So packaging has to be disposed of once it has performed its task. And in most cases, the cost of disposal falls on the public body, who is the consumer, and not on the supplier. So take into consideration the amount of packaging that will accompany a particular good. Maximum use of materials. There are many grades of recyclable materials. Where possible, seek materials that have been used once and are being reused to perform a repeat or new function, rather than materials that have been reused from a manufacturing process waste, which has never been used by a consumer before. So basically seek materials that can be recycled. No polluting with minimum use of toxic chemicals. Not only do the products help reduce your environmental impact, but choosing low polluting alternatives often means you can avoid lengthy assessments in terms of cleaning, staff, and lab technicians. Go into the social criteria, so health and safety standards. These are very, very important. It is and should be evaluated in terms of products, health and safety. And this includes electrical equipment, vehicles, cleaning chemicals, and furniture. So of course, it will not only impact the health and safety of your employees, but the public at large. In terms of local production, sourcing your purchases from local suppliers means that their economic benefits can be felt in communities in which you live and work. The inward investment can help ensure ongoing economic sustainability of your local area through job creation. Ethically sourcing goods and services. So you should seek to ensure that the products you buy are not exploiting child labor or labor and economies in the developing world, and that you meet recognized fair trade standards wherever possible. Competitiveness can never be overemphasized, as it includes potential savings for the economy. It increases the supplier base and the development of the local industries within the economy, thereby leading to economic development. Products in markets could fail and become hazardous to people or the environment. The reasons are manifold. They may not comply with relevant standards. Manufacturers may have slumped on manufacturing controls. Suppliers may take a chance to see whether they could get away with providing substandard products to public bodies. Consumers, and in this case, public procurement practitioners generally, may not always be able to distinguish between products that may fail and those that may not. It is in this view that expectation is that the quality infrastructure will help protect procurers of goods and services against substandard goods and engender greater confidence in local suppliers. We wrap up the presentation.